Good day, everybody. Psychedelic, nonprofit, civil rights attorney Greg Lake here, coming at you in Theo SK YouTube channel. Have a very special episode today that was procured, I guess, through my dealings last week with some of my clients. Before we jump right in, I would be so very much grateful and appreciative if you could like, comment, subscribe to the channel, maybe share it with your friends. For those that are probably going to show up for this specific talk, yes, this channel is going to be right on point with things that you're going to want to learn and discuss, amongst other, I guess, a little bit more general topics outside of entheogenic religious law necessarily. So if you could do that for me, it'd be very much appreciated. I'm going to try to get you in and out of here just as quick as possible today. Not going to harp on it too much, but hey. So according to the title, right, this is going to be a discussion of free exercise rights under the First Amendment of the Constitution, really in light or in consideration of those who consume and serve psychedelics and entheogens as part of their religious practice, with an even further emphasis. Hey, everybody, what's up? What's up, Chris? What you doing, bro? Nice to see you, man. But especially in light of those who are particularly in states that have legal psilocybin programs and not strong state level religious protections, right? Because in that case, people need to lean back to the First Amendment protections, because obviously the Federal Religious Freedom and Restoration Act, which does provide very robust protections, does not apply at state level, right? In state cases, okay? And so just to put it all out there, I was speaking with a client and good friend of mine this last week who is in Colorado, where they have an actual, therapeutic medical psilocybin program exception to their otherwise Controlled Substances Act, right? And so what has happened, just from my understanding, is that the requirements to get the medical therapeutic licensure are very, very rigid, I guess, very costly. And so there's a whole contingency of people who are choosing to rather operate as a religious practice, right? And at the end of the day, right, this whole distinction between like medical scientific psilocybin versus religious psilocybin, it's all erroneous to me, just in my personal opinion. Why do you say that, Greg? Well, because the science tells us, one, that these things are pretty damn safe, but it also tells us, too, that very reliably, at a very high rate, people have primary religious mystical experiences when consuming these substances, right? So whether you're an MD or a shaman, if the people that you're serving or you taking them are having religious experiences, well, what is that? Oh, man, that might be a religious practice, right? So in the grand scheme of things, this is all very ridiculous, right? It's absolutely very ridiculous. But here we go. So today, and this is another reason why to like, comment, subscribe. I'm about to give you some very, very, very niche information. This is not legal advice, okay? I don't know what your specific circumstances are. This is just my general thoughts and ideas on the state of the law as it stands in these specific circumstances. And so, yeah, so that's what I'm going to give you today. Obviously, if anyone wants to meet or consult with me, I will plug my stuff at the end of this, so stay tuned. But let's go ahead and jump into the educational portion, right? Okay, so we're just going to kind of do a hypothetical as like kind of a background motif. Hey, what's up, Lisette? What's up, Lizard? Glad to see y'all. There's my people. I love y'all. I love you, Chris. Thank y'all very much. Debbie had to bone out a little bit, but hey, we're going to be right on track, okay? And so we're going to kind of put ourselves in the position of one of these people in Colorado that's operating religiously and not within this medical model framework, which again is just very erroneous, right? The science just completely blows all this out. But anyways, it is what it is, okay? And as we remember, right, so let's just talk real quick about sources of religious freedom protection in this country, okay? So at the very top of the list, now this isn't strength of religious protection, but supreme protection comes from the First Amendment, right? The free exercise clause, right? For it basically, it guarantees you can believe whatever you want religiously, right? Now, when it goes to religious practice, religious action, it basically limits, if you read the Fulton versus, and we're going to talk about it, the Fulton versus Philadelphia opinion, when we look at the concurrence, Alito said that, basically the spirit of the First Amendment is protecting religious conduct or religious practice, which neither endangers the safety interests of the state, so you're not harming another person, or the peace interests of the state, meaning you're not being unpeaceful or bothering your neighbors, okay? So that's the First Amendment, essentially, in a very generalized nutshell. We're going to get into some more specifics. But at the federal level, you also have the Religious Freedom and Restoration Act, right? Now, it only applies, okay? It only applies to federal actors, federal cases, okay? Which is good. It's very strong, right? Because under the Religious Freedom and Restoration Act, any instance, any law which substantially burdens religion is subject to the strict scrutiny, which I'll describe here in a little bit. But only federal laws, federal actors, right? Federal agents, federal laws, okay? But the First Amendment is a bit more nuanced, okay, which is really the heart of what we're going to talk about today, is a little bit more nuanced as to when that strict scrutiny, meaning that very harsh, I say very harsh, strict scrutiny means it's very tough for the government to prove their case. And I'll talk a bit about that in a minute, right? So it's a bit more nuanced. It doesn't apply all the time like it does under RFRA. Now, then you go back down from there. State constitutional provisions. What does your state provide you, as far as religious protection is concerned? Some provide more protection than others. Today, we're going to be talking about Colorado. Now, I don't practice in Colorado. I don't claim to know a lot about the Colorado state constitution. But again, we're talking about the federal First Amendment because that does apply to state actors in Colorado, okay? And then many states, I'm assuming Colorado does not have a state level Religious Freedom and Restoration Act. So a lot of states, because the First Amendment protections are a little screwy, a lot of states wanted to firm up their protections in their state, like the federal RFRA, passed their own RFRA Act. Okay. And we're going to be talking about the singularism. What up, Trip? Man, good to see you, dude. Good to see you, man. Please like, comment, subscribe, dude. It'd be very, very helpful. Anyways, where was I at? Oh, yeah. So anyways, states pass their own RFRA protections. I don't think Colorado has one, but we're going to be talking about the Singularism Mushroom Church case out of Utah. I believe it's still ongoing, but we're going to be talking about the preliminary injunction that the judge entered because the judge brushed upon the First Amendment. Even though Utah had their own RFRA Act, the federal judge brushed upon the First Amendment exactly on the points that we want to talk about today, okay? Now, again, let me back up for a second. Under the First Amendment, as opposed to RFRA, whether this strict scrutiny, very hard on the government test applies, and when properly asserted, the government can hardly ever meet the test. But it only applies when the law at issue is not what the Supreme Court has termed neutral and generally applicable, okay? Now, let's run this down in your normal state where, okay, let's say we're in a state with not good state level protections like California, right? Not good state level constitutional protections. There is no state RFRA law. And you catch a state case, let's say working with psilocybin mushrooms religiously, okay? So what the court would probably look at is, well, I know what they look at is the California Controlled Substances Act. And as far as psilocybin's concerned, it is forbidden for both, in Schedule 1 for any use, right? Any use, right? Out of 6 really limited, research purposes. So that's what they would probably generally say is neutral and generally applicable. Now, we're going to talk about this Tandon case, right? And that might switch that up. But we're just going to say before Tandon, definitely the Supreme Court would have probably seen it that way, right? That you have psilocybin's banned all the way around, more or less. That's generally applicable and neutral. And in those circumstances, under the First Amendment, under that paradigm, instead of having to show a compelling governmental interest and least restrictive means of advancing that interest, the government would only have to show that there's some rational basis as to why they're going after you. Okay. So pretty much out there, right? On the rational basis part, right? And that's what a lot of people in Colorado are worried about. They are still under the impression that the Smith case, and I'm not going to go into the Smith case, although I do note it was a peyote case, basically said that, yeah, the drug laws are generally applicable and neutral. So they're thinking that's going to apply to them in Colorado under the First Amendment. I think I'm going to change your mind on that today, talking about Tandon. So how did this Tandon mess come around? Well, COVID. It all happened during COVID. There's a lot of bad stuff happening during COVID. Hey, there's some good stuff in the law of entheogenic churches that happened during COVID. And Tandon is a case that came out of California. It actually went up and back from the Supreme Court like 6 times, okay? And that happened a lot. these states kept trying to, New York and California in particular, really were hammering down on Christians, Catholics, and the number of people they're allowing them to meet with, the whole time allowing businesses to just wear a mask and do what you will. So it created a real tension. And the Supreme Court was at first kind of gently stepping, trying to keep the refinement at a minimum. But after 6 times going up, they said, look, here's the deal. Like, we're just going to like broaden this way out. We're going to define further, okay, exactly what it means to be generally applicable and neutral. And as we'll see in a second, the way that they define it really makes many laws, like the controlled substances laws at this level, potentially not generally applicable and neutral no more. Okay. So right now, let's go ahead and jump into the Tandon case. I have it pulled up here. I'm going to add it to the stage. I'm going to pull it over here in front of my screen where I'm looking at me. I love y'all, man. Thank y'all for being here. So again, this is a case out of California. Tandon v. Newsom. Make sure I got, okay. Just making sure I got it there. There we go. So I'm just going to read the key holdings here for y'all, because then we can X out of it and I'll talk about it. But anyways, again, this had to do with I think it was a Catholic church. But anyway, the people were gathering at home. So they were trying to limit their number of people. That was a problem. And all these problems with people with religious gatherings, yet the businesses were going pretty much carte blanche. Okay. And they more or less, pardon my language, pissed off the Supreme Court. But let's see. Let's see what they have to say here. They say, first, government regulations, and this is under the First Amendment, free exercise clause, are not neutral and generally applicable, and therefore trigger strict scrutiny under the free exercise clause whenever they treat any comparable secular activity more favorably than religious exercise. Okay, so let's back up for just 1 second and go to the controlled substances laws. Like I was saying, under your normal circumstances, psilocybin medical, psilocybin religious, there's no difference in the way those are treated. No one can do it, right? So there's no comparability there. There's no comparison to really be made because it's just flat, restricted, okay? But now what they do, the Supreme Court here, this comparable word, they define comparability up here. And goes second, whether two activities are comparable for purposes of the free exercise clause must be judged against the asserted government interest that justifies the regulation at issue. Okay. So here, if we think back about your normal run-of-the-mill Controlled Substances Act, you got a person. Let's think about that. Before I jump into that, let's back up for a second. The same interest in public health and safety that regulates the medical exceptions to the Controlled Substances Act are the same interests that would theoretically prevent someone from serving, for instance, psilocybin religiously, right? So we can look at this one way right now, right? Well, we could say, well, look, doctors under pretty much every state controlled substances law, well, they're able to prescribe fentanyl patches, benzodiazepines, other very dangerous narcotics out into the public, right? Pretty dangerous. It creates a real health and safety issue. And if you know anything about the science of psilocybin, I can tell you right now, putting fentanyl patches out into the public or benzodiazepine don't even hold a candle in terms of safety. Serving psilocybin in pretty much any instance is going to be much safer than giving someone a prescription of fentanyl patches. It just is. So, I mean, right there, you could say that there would be an argument potentially to say that, well, even if there isn't an exception for medical psilocybin is so much safer than these other drugs that you just willingly handle out that, hey, it might not be generally applicable and neutral under the State Controlled Substances Act. Again, that's just an argument I've formulated. That specific one, to my knowledge, has not been tested yet. But again, now when we looking at, now that you've read this, now I think you can understand that when a state does have an exception for medical therapeutic psilocybin, but none for a comparable religious context, right? That creates an issue. And we're going to see how the court in the Singularism case, sorted that out in favor of the religious practice. So we'll see that in a minute. I'm just going to read a couple other quotes here. Third, the government has the burden to establish that the challenge law satisfies strict scrutiny. To do so in this context, talking about COVID, it must do more than assert that certain risk factors are always present in worship or always absent from the other secular activities the government may allow. Instead, narrow tailoring requires the government to show that measures less restrictive of the First Amendment activity could not address its interest in reducing the spread of COVID. So here, what they would say is, well, how come the religious people can't take the same precautions that the medical scientific people do in protecting public health and safety? And we can draw a direct analog from this case, right? Because COVID, what's their interest in helping to reduce COVID? Health and safety, right? So it's this case is comparable to what we're talking about in that way. So I just wanted to point that out. I'm not going to do that. I'm going to read this though. This is very important just generally when we're talking about free exercise rights. Okay. They say applicants are likely to cede on the merits of their free exercise claim. They are irreparably harmed by the loss of free exercise rights for even minimal periods of time. Okay. So remember that. It doesn't take a lot of infringement upon your free exercise rights to be considered legally irreparably harmed. And that really mostly matters for injunctive relief, but it could potentially also be argued on a monetary damages 1983 claim. Okay. So I just wanted to point that out. So let me back out of here real quick and just talk for a second. So again, we've just looked at the Tandon decision, right? So what's the difference now with Tandon? Well, Tandon really focused in on how we determine whether law is generally applicable or neutral. And it says we actually look at the interest advanced by the state law. And if the state's interest in this activity, the secular activity underlying it, health and safety in our instance, is the same as the religious activity, health and safety in our situation, well, then those are comparable. And if there's a discrepancy in the treatment, and the state can't show that the religious people could never, or if they're actually using the same precautions as the secular activity, that it still endangers the state's interests more. Okay. And again, I'm about to pull up the Singularism case and show you how the federal district court in Utah resolved that situation. Hey, my Charlie Kirk people, we're in Utah today. How about that? Let me see. So let me pull up. And we'll talk a little bit about the facts. I'm not going to go into all the facts of the what am I doing? Sorry, y'all. I don't know what that is. Let me do this real quick. Let me pull this up. Okay, there we go. Go back up to the top. All right. So I highlighted some portions of this just to give y'all some context of this case. What is going on? Why can I not find the... there we go. Got it now. All right. So now we're going to be looking at the Utah case, okay? This is going to be the Singularism Church case out of Utah. Let me go ahead. And now that I'm looking at it, y'all, I think this is in the same district as the Charlie Kirk stuff. Damn. All right, so let me pull it up here so that way I can look at it while we go through it. This was from February 20th, 2025. This is an order granting a motion for preliminary injunction by the church, okay? And I'll just read some of this from the start. You know, they say, our nation was built on an essential commitment to religious freedom. As the Supreme Court has repeatedly recognized, this guarantee of religious liberty lies at the heart of our pluralistic society. Many states have enacted special laws modeled on the Religious Freedom Restoration Act to provide additional protections for religious exercise. Utah passed its version of RFRA just last year. Laws like these further instantiate the guarantee of religious freedom so central to our republic. But for that guarantee of religious liberty to mean anything, the laws must protect unfamiliar religions equally with familiar ones, both in design and in practice. In this litigation, the religious exercise claims of minority and entheogenic religion put the state of Utah's commitment to religious freedom to the test. You know, when I first read that, y'all, I already knew what time it was. I was like, that's good. Yeah, that's good. I like that. I like to hear that. But I go on. Plaintiffs are members and associates of a new religious group called Singularism that uses psilocybin mushrooms in its religious ceremonies. After the government raided their spiritual center in November 2024 and seized their mushrooms and scripture, plaintiffs filed for a temporary restraining order and preliminary injunction in state court, claiming that the Utah RFRA, Utah Constitution, and federal Constitution, First Amendment, protect their use of psilocybin, a psychedelic substance otherwise legal under the Utah Controlled Substances Act. The defendants then removed the case to federal court. So the state removed it from federal court after they moved for an injunction in state court. That's why the federal judge here is ordering the injunction. All right. And I've talked to the guy who runs this church. I've talked to his attorney. They're really good people. They're making a good stand for the cause, right? So God bless them. I hope the best for them. I think they're in good hands in this court. But anyway, so it goes through, the leader Jensen's spiritual evolution using psilocybin mushrooms, Singularism's beliefs. If anybody wants this case to look at, entheogenic@gmail.com, just shoot me an email. Hey, like, comment, subscribe first, right? Shoot me an email and I'll be glad to send it to you. It's a good read. It really is. It's just this whole thing's a little bit beyond the scope of this particular lecture. But I did highlight some sections earlier today to share with y'all. I mean, there's some very particular ones I was going to share here at the end. But anyways, I'm going to get there. I promise. God bless y'all. I love y'all. Please like, comment, subscribe. So here we go. Boom to boom. And I'll tell you just real quick, I'm obviously a scholar on definition of religion under the First Amendment, especially in light of entheogenism, my third book was on, and he goes through a great analysis here. I'll probably do another video just on that. It's incredible. And I'll say this about this case. I've been expressing opinions on these areas of the law for quite some time. Some people call me crazy. There weren't exactly cases on point. This one vindicated me in a lot of ways. And I've made some Patreon videos about that and stuff. And maybe I'll do some more videos here. But man, this opinion vindicated me in a sense, in a lot of ways. Okay. Here is one thing that I did want to stop in the context of defining sincerity in religion. The whole time I've been telling people that I've been working with that, hey, in your formation, organization documents, whatever, like citing to scientific research is cool. This is actually an area where science and religion meet. Remember earlier when I said that the science proves that people have primary religious mystical experiences? Okay, there you go. So the science proves when we say, at least to the degree that we're being sincere, that we use these things religiously. Does that make sense? And so here the government tried to twist that around and say, no, because they're citing science, they're using this for secular reasons. The judge says, no, no, no. He goes, Singularism citations to scientific and medical research on psilocybin hardly undermine its claims. An overlap between scientific and religious reasons for a practice cannot render those actions any less religious. Indeed, many religious practices in more common religions, such as gathering in community for music, prayer, and fellowship, can be justified by a litany of non-religious reasons in scientific research. Those non-religious justifications do not make the practice of communal worship any less religious. And the same goes for Singularism's practice of psilocybin tea ceremonies. So I just wanted to point that out, right? Because that's something I've been saying for a while. So I just want to say, Judge, you're right. You're right. And then they also tried to throw Mr. Jensen, the leader of the church, the fact that he's making decent money, running the church at him. Judge leaned into it a little bit, but then right here he goes, the Roman Catholic Church, which certainly qualifies for religious protection, is one of the largest and wealthiest organizations in the world. Not hating on the Catholic Church. It's true, though, right? And that's a good comparison. I think that's fair, right? Is that fair? Like, comment, subscribe. Let me know what you think in the comments. So anyways, getting down here. Sorry, y'all. It's a long opinion. Okay, so here at the end, right, because the primary claim by Mr. Jensen and them was under the Utah's Religious Freedom Restoration Act, right? They don't necessarily need to lean on the federal constitutional protections necessarily, but in alternative pleading, a good litigator is obviously going to allege that as well, kind of as a fallback position, right? Even though the state law is kind of your primary vehicle for protection. In this instance, especially because of it's modeled after RFRA, that it doesn't have this generally applicable neutral requirement, okay? But anyways, the judge goes into it, right? And really Well, I'll talk about it in a minute. Because, but assuming that some form of regulation is necessary for the government to protect the public, talking about the public health, an alternative is readily at hand in the Utah Controlled Substances Act itself. Two alternatives in truth. First, the Act creates an exemption for psilocybin administered as part of behavioral health treatment programs developed by certain healthcare systems and imposes relatively few restrictions on how covered healthcare systems may use psilocybin. The main restrictions are that the drug must be in phase 3 testing by the U.S. Food and Drug Administration, that it must be under the supervision of a licensed provider, and that it may not be used for minors. Other than that, it appears that healthcare systems have wide discretion to determine how to administer psilocybin. Defendants do not attempt to explain why the government, like I was saying earlier, and again, this is strict scrutiny, right? The government having to show, I'll take that back. Talking about the comparability, they need to show why the precautions taken by the medical scientific people could not be taken by the religious people and achieve the same level of protection for public health and safety. Defendants do not attempt to explain why the government cannot implement an analogous system of oversight for singularism since religious practice. I take this back. This is the least restrictive means, compelling interest part of the analysis. The evidence in the record suggests that it would not be particularly difficult to do so. Singularism already does not administer the drug to minors, and the Utah Department of Commerce Division of Professional Licensing recently determined that Mr. Jensen qualifies for a clergy exemption to the licensing requirement for mental health care practitioners. It also likely would not be difficult for plaintiffs to ensure that their psilocybin is of the same variety allowed by the behavioral treatment exemption. So, one argument that the state made here, because it's kind of a gotcha moment, because the science certainly doesn't justify the idea that singularism, Mr. Jensen, could use the same precautions as these health providers and achieve the same safe result. Okay. And so that's what they're pointing out here. Now, one thing that did vary a little bit were testing of the substance that's being served. Under Utah, the way I took it is that they require that it be tested to make sure it doesn't have mold or any other contaminants in it. However, Mr. Jensen, who was getting his mushrooms from Oregon, was having them tested before they were sent to him. And then he also personally ingested some before he served them to others. The court here found that sufficient to cover that potential gap between potential health and safety risks between the medical and the religious models. Okay. And just for kicks and giggles here, they also say, second, the act creates a religious exemption for peyote. So that would be a little bit different argument, like religious discrimination, but still under the First Amendment, right? In the 14th. So this is also an in that if Colorado has a religious exemption for peyote, could also provide an argument under the First and 14th Amendment. And it says that exemption provides civil or criminal liability may not be imposed under this section to any Indian who uses, possesses, or transports peyote for bona fide traditional ceremonial purposes in connection with the practice of a traditional Indian religion. The act requires no more of the claimant than the claimant's use or possess or transport the peyote for sincere religious purposes connected with a Native American religion. And the exemption provides the claimant an affirmative defense established by a preponderance of the evidence and a prosecution alleging a violation of the act regarding peyote. Peyote, like psilocybin, is a Schedule I controlled substance. Defendants do not attempt to explain why the government cannot create a similar exemption for sincere religious use of psilocybin. Defendants thus have not satisfied the least restrictive means component of strict scrutiny, so plaintiffs have shown a likelihood of success on the merits of their statutory free exercise claim. Although the likelihood of success on the merits often controls the outcome in a case like this, talking about the preliminary injunction, one where the motion for preliminary injunction is based on a quasi-First Amendment claim, the court must still consider irreparable harm in the public interest. Plaintiffs have satisfied the court they will be irreparably harmed. Remember what I said earlier about Tandon? They spoke directly to this. They said any loss of religious freedom, even momentary, is irreparable harm. Defendants' enforcement of the Utah Controlled Substances against plaintiffs and defendants' continued possession of psilocybin mushrooms seized in November deprived plaintiffs of their religious sacrament. And plaintiffs have introduced evidence that singularism is losing adherence because of defendants' action. No amount of damages can later compensate plaintiffs for these injuries. They could have cited Tandon there, but it's all good. They still reached the right result. As to the public interest, it favors plaintiff's assertion of their quasi-First Amendment rights, prohibited defense have not shown plaintiff's actions have threatened public safety. So long as the government can achieve its interest in a manner that does not burden religion, it must do so. And that's the Fulton versus Philadelphia case that I mentioned earlier. So that's it for the singularism case. So now I'm going to go ahead and tie this up for everybody here. So again, as we saw, in a state, okay, and we could go on and on about other states without legal psilocybin programs. Like I said earlier, when we compare it to like fentanyl patches being prescribed, stuff like that, that is definitely an argument. And the way that that's going to come down depends on the specific circuit that the state's in. How have they interpreted the Tandon decision? I've looked at several different circuits on Tandon just because I'm a nerd. That's what I do. And they do kind of treat it at different levels of abstraction. And that's normal for Supreme Court precedent coming down the pipeline. But as we see here, the way that the Utah District Court here is kind of interpreting the First Amendment in that regard, I think is correct, in the sense that if you have an actual like exception to the state controlled substances law for a medical therapeutic psilocybin program, well, then that creates a real issue if you're not also accommodating the religious practice. So my Colorado people, does that make sense to you? Obviously it's going to come down to, and again, this is just my opinion. I'm speculating. You know, are you following the same kind of safety? And again, this is just with psilocybin, okay? I'm not going to speak on any other potential psychedelic and entheogenic sacraments. I'm just going to speak on psilocybin. Are you using the same health and safety precautions required under the Act, including potentially testing the sacrament, okay? Just speaking, you probably would want to do all that, right? So that way, if you have to go to court, you know, it's going to be very difficult for them to show the state, if you're doing everything otherwise required under the state act, why your religious practice endangers people more than the people who are doing it therapeutically, medically. Let me just say this, my personal opinion. I saw a video yesterday where it's like 3 grandmas tripping on mushrooms, and they're like doing a group session under the Oregon Psilocybin Act. And let me tell y'all, I mean, the ladies were okay. Don't get me wrong. It seemed like they had a decent time or whatever, but it just was real lapsadaisical, loosey-goosey. When I've seen people working with these religiously, it is not like that. It is, you know, we're going to sit here, we're going to process, we're going to do this, and seems just a better, safer container to me. Just my opinion. And maybe it was just a practitioner working with these ladies in that video. But that's where I'm at on this thing with the, you know, Colorado deal. And just so we're clear, yes, Utah District Court's not in Colorado, but they are within the same federal judicial circuit. And if there's not another like opinion out there, I would tend to think that the Colorado court would lean heavily in on how the Utah court did this here, essentially a case of first impression of sorts within this paradigm and framework. Okay. So I hope that helps y'all. And I guess I'll just go plug now. Obviously, I have courses for practitioners. I help consult on churches. I have forms on my website, and you can book a consultation. www.entheoesq, that's entheoesq.com. Always, you can feel free to email me on my business email directly. That's george.lake, L-A-K-E, at entheo, E-N-T-H-E-O, ESQ.com. I'd be glad to meet with you, help you out any way I can. This is what I do for a living. I love it. It really brightens up my soul to help y'all. Because, you know, as we're going to be talking about on this channel, like, comment, subscribe, I'm going to go through my whole journey through all this. It's both my personal spiritual journey and legal journey through this. We're going to break it all down. Even some of my other fans that might not be so hot to trot on legalizing or approving of psychedelic, entheogenic religions, by the time they get done with my series of videos, they're going to be like, where can I go to a ceremony? Just saying. No, I'm just kidding. I don't advocate or promote the use of any of these substances here. I absolutely don't promote breaking the law in any way. But we're going to have a good time. We're going to learn a lot. So now I'm going to jump into the comments, y'all. Just fair disclosure, I'm hungry. I'm going to eat a little bit, but I'm going to get to your comments before we finish up this video. I see I got my ride or dies here. So Christopher Knox, good to see you, man. He knows me. We work together. Good to see you, man. Love you, brother. I hope y'all are doing well. God bless you for everything. Lisette, man, so honored to have you here. So honored to have y'all here. I love y'all. I'll be doing another Charlie Kirk video on the other channel here within the next several days. I've been collecting some stuff to over there. Lizard, what's up, man? I know this probably interests you. Lizard, I think Lizard is a buddy of ours over there from UK, I think South Africa right now, who's also into mental health space. So Lizard, good to have you, man. We love you, brother. Trip. I know Trip. Trip knows me. Glad to stop in. I'll listen to the recording while I commute this week. Got to get back to studying today. God bless you, brother. God bless you. And we'll meet this week. Man. Lizard said he's going to watch later. Connection super slow. All good, man. All good. Let's see. Debbie's back. Where you been, Debbie? I thought you said you had some painting to do for your kids get home. I guess you back, man. We love you. Thank you for coming and showing up. I love y'all. Susan. Oh, Susan, man. God, it just warms my heart every time I see you, love. God bless you, man. God bless y'all for supporting this channel. We're kind of at the end of the comments, so I guess I'll just Lisette, I'm honored for you to be here. Oh, here goes Basic Niche. Oh, my boy, what's up? Yeah, I've been listening. My takeaway was I can start a church of weed in Kentucky. So, man, that's a whole other video. I have scrubbed pretty much all of the cannabis jurisprudence. If that's something that you want to talk about, Niche, just shoot me an email. I'll meet with you for free. And we can talk about it. I'll do a video about it too. But there's, with the cannabis, it's a little bit different animal for some peculiar reasons, but not impossible. Not impossible in my guesstimation, just my guesstimation. But let me know if you want to talk about that sometime. I'd be glad to have a Zoom meeting with you or a phone call about it. And I'll do a video. Chris, excited to share the church with our community. Thank you for your service. You're a good man, Greg. Thank you, Chris. And if you could share this YouTube channel, brother, man, that would be killer, bro. That would be absolutely killer with your people, your email list. And I'm still signed up to come talk at the Psychedelic Society for you and your wife. So just let me know when y'all want me to do that. And yeah, let's spread the love, man. Let's spread the love. So just so y'all know, I was doing comedy shorts and some freestyle rapping and stuff on this channel, but I was having a talk with my GPT today, and I think what I did is I actually started up a Instagram page for this channel. But I think for the meantime, because I'm really going to try to more or less niche out in this type of subject matter, I'm going to keep that on Instagram for a bit and just really focus in on this more so. I'll be glad to share that Instagram page with y'all. But anyways, in regards to this channel, the niche stuff, obviously I have, 1,500 followers on 2 different Instagram accounts full of people who are interested in this. I have a TikTok account with about 700 or 800 followers, definitely interested in this. And so I'm spreading the word about this channel because I had a Patreon and I just wasn't feeling it after a while. And then I monetized my other YouTube channel and I thought I really feel more into the YouTube. So I'm going to be bringing all that here. So I'm just going to have to get the word out, but we should be monetized on this channel within 30 to 45 days tops, I would imagine. So that's a good thing. Thank y'all for all your support. Any sharing of the word that you can do would be very much appreciated. Dr. B. Oh, Dr. Pearson's here. Greg is the gold standard for entheogenic law, and we're all blessed. Oh, God, Dr. P. Man, thank you very much. Yeah, and just so y'all know, most of the people, I've formed over, 130 entheogenic churches across this country over the last 6 years and litigated on behalf of, I've never had to litigate on behalf of the people I set the church for, thank God, but litigate on behalf of other practitioners. But most of the people I've worked with are very highly educated, very committed community, like pillars of their community, who want nothing more than just to commune and help people in the peace and safety of their own abode or wherever they got land or whatever. These aren't druggies. These aren't hippies. These are people that are leading your community, just so y'all know. And Dr. Pearson's one of those people, very distinguished doctor, very good man. A lot of the people I work with are medical practitioners. I can't tell you how many medical practitioners I've worked with that had their own religious, spiritual experiences with it, read the science and said, you know what? I'm going to do this primarily instead of practicing medicine because, hey, I got into medicine to heal people. And this looks like it's doing a much more effective job than all these pharmaceuticals. And the science plays that out, right? So, hey, and that's what I'm saying. Science, religion in this go hand in hand. They essentially prove one another up. And I'm going to be doing a whole series of episodes just on that whole host of, I'm not going to say issues, but paradigms in and of themselves. So stay tuned for that. Like, comment, subscribe. Okay, let's see. Debbie, love y'all. Y'all have a great rest of your weekend. We will, Debbie. I'm about to go down here and cook some chicken and some rice and some salad for me and my wife. I'm getting, here we go. Basic Niche. Keep me going, Basic Niche. I'm trying to cook chicken, man. What you doing, dude? Buddy Bear, what's Niche doing? He's trying to keep us here all day. Just kidding, brother. Have you ever been to Earth Skill gatherings? I could see you teaching a class at one for sure. No, I haven't, Basic Niche. But I have spoke at many conferences. I've spoke at festivals. I haven't in a while, which is okay. I've been getting myself right. You know what I mean? But I think I'm back to where, yeah, man, I would love to go and travel and speak. I used to be able to do it for free. I might not be able to do that now. If my costs are covered, I definitely can travel to go speak. I don't need to be compensated much of any money at all. I love to just go out and meet people. And the reality is when I'm speaking at gatherings like that, I mean, I usually get some business at it, So, hey, win-win. So if you know anybody that wants me, he goes, them's my people. I'm going to look it up, Niche. Earth Skill gatherings. If you want to put me in contact with them, I would be more than happy to speak with them. And, if they want me to come give a talk. And again, this is niched out on the law, right? But I know a lot about the spirituality of it, the science of it. I've been certified in a criminal court in Texas as a general expert in psychedelics with an emphasis on health and safety. So I've got a pretty wide array of stuff I can speak about in this regard. And that's why I got this channel going. It's super niche and people aren't going to get this information anywhere else. Because I can just tell you, I litigate all across the country, these cases. Why do I litigate across the country? Because there ain't no other lawyers that can do it. And so I get accepted in pretty much every court because I'm a niche specialty expert. Judges know I'm going to be able to educate them appropriately on the law, whether they agree with me or not. And so, yeah, so I can speak all over, I guess. Yeah, man. But anyways, look, I'm going to go. It's Sunday, man. I'm going to close this down. God bless each and every one of you that came today. Please like, comment, subscribe, share the word. I'll probably be back tomorrow morning with another video. I think tomorrow morning I'm going to do a video about my entheogen-induced religious spiritual experiences that led me to write my first book. And why am I going to do that? Well, quite frankly, one of my friends who is involved in one of those experiences called me this weekend and brought it up. And so it was a sign. I'd already been thinking about it in the ether, and I thought it was a sign to go ahead and do that episode. So I'll probably do that tomorrow morning. All right. God bless. I love each and every one of you. Time for me to go eat and relax for the evening. I've been working since 5 o'clock this morning, but it's been going good. So I'm running about 12 hours today, Sunday. Then I'm gonna pack it up. Susan, no problem being late. Just your presence, even for 10 seconds, is a blessing in my book, quite frankly. You've been such a supporter of me. I owe so much to you and all my other big time supporters and long time people I've been working with here. God bless each and every one of y'all, for real. Y'all relax for the rest of the day. Enjoy yourselves. I'm about to go do the same. And we're gonna turn it up a notch on this channel. But anyways, I love y'all. I'll be back tomorrow. Please spread the word. All right. Love y'all. We'll do, Basic Niche. We'll see y'all. God bless.